Hello friends, in the series on the income tax cases, today we will discuss a very important case on writ petitions. The name of the case is Jeans Knit Private Limited versus Deputy Commissioner of Income Tax and others. This case has been reported in 390 ITR at page number 10. The matter has been decided by Supreme Court and the date of the judgment is 8th December 2016. In this case, the assessee filed the special leave petition before the Supreme Court because the assessee has already filed the various writ petitions in different high courts against the notice under section 148 and the reasons recorded for issuing those notices. The courts have rejected those writ petitions on the sole ground that the assessee has alternative remedy. The assessee is relegated to the alternative remedy and the writ petitions were dismissed in limine. When the assessee filed the writ petitions, the court said that although the Supreme Court is very conscious that the high courts have rejected the writ petitions by referring to the Supreme Court judgment in the case of CIT versus Chhabil Dass Agarwal 2013, which has been reported in 357 ITR at page number 357. The Supreme Court further said that the facts of the case of the assessee and the facts of the case of the CIT versus Chhabil Das Agarwal on which the department has relied are not similar, and the court referred to its very old judgment, that is Calcutta Discount Company Limited versus ITO 1961, which has been reported in 41 ITR at page number 191. The court in that case has said that alternative remedy is not always sufficient for refusing a quick remedy, and sometimes to avoid the lengthy proceedings and unnecessary litigation, the writ of the assessee should be considered. In this case, the assessee has challenged the various notices and the reasons in the various high courts, but as all we know that the department always take the plea that the assessee has the alternative remedy, and mostly on this point alone the writs of the assessee are not entertained by the Supreme Courts, by the High Court. So by this judgment we can get an insight that where the assessee is able to prove that the notice has been issued without jurisdiction, it is ultra vires the provisions of section 148, or to make its case to file the writ, then his writ should be entertained. The conclusion of this case is that writ cannot be dismissed only on the ground that alternative remedy is available, because according to the Supreme Court in its own judgment Calcutta Discount Company Limited versus ITO, in that case the Supreme Court has very consciously said that alternative remedy is not always sufficient for refusing a quick relief to the assessee, and the assessee has to face very lengthy proceedings and unnecessary litigation when the assessee is always relegated to the normal alternative remedy, that is CIT appeal, ITAT, and in that proceedings the time involvement, the cost of the assessee is very high. So when the assessee is able to make it case that there is some palpable mistake, there is some apparent mistakes in issuing the notices, like the assessing officer do not have the jurisdiction, the notice is time barred. So in all those cases the writ of the assessee should be entertained, because if the assessee will go into the normal proceedings, then it will take a huge lengthy time and the assessee will be just stuck into the wheel of the litigation, and it will a wastage of energy and a lot of resources for the assessee and for the income tax department also. So always the writ of the assessee should not be dismissed solely on the ground that the assessee has alternative remedy. At the end of this video, once again I am repeating the name of the case. The name of the case is GeneSnet Private Limited versus DCIT and others, and this case has been reported in 390 ITR at page number 10. The matter has been decided by Honorable Supreme Court and the date of the judgment is 8th December 2016. Thank you, friends.